We will start today the trial of warrant cases by magistrate. Remember why the chapter says trial of warrant cases by magistrate? The reason being that the session trials are also of warrant cases. We will now start trial of warrant cases by magistrate. Now, when we talk about trial of warrant cases by magistrate, remember there are, you will find two subcomponents are there. So when we talk about the trial of warrant cases, remember the by the magistrate, all cases where punishment is more than 2 years, those are all warrant cases. So there may be in warrant cases, some cases can be cognizable, some cases can be non-cognizable. If the cases are cognizable, impliedly those cases are started through police report. So that police has registered FIR, the charge sheet is submitted, and the case brought for the trial before the magistrate. Those are non-cognizable cases, or even in cognizable cases when FIR is not registered, a person may file complaint cases. So accordingly, cases start as a complaint cases. So when there are two processes in which the cases start, either it will start based on the police report or it will start on the base of the complaint. So when we look at this chapter on trial of the warrant cases, you will find two kinds of process are written there. Two processes are there. One part is talking about the cases which started on police report. Other part is talking about the cases which started otherwise than police report. That means complaint cases. So otherwise than police report implies only complaint cases. So these are the two ways in which the cases can start within the criminal justice system. So this chapter talking about both the things. So let's first see what it talk about. So first is talking about cases instituted on police report. So remember, when the cases instituted on police report, it implies that a case was started by FIR under 173 BNSS. Then police has submitted their police report under 193 BNSS. After police report submitted, magistrate has taken cognizance under 210 BNSS. And thereafter, the magistrate proceed for the trial. And there this chapter comes. So what the next step? 261. Basically, we did discuss 230 earlier. This is a procedural requirement that before either commitment or before proceeding the case, the magistrate where the charge sheet is submitted, that magistrate will ensure, so that magistrate should ensure that whether the copy of the charge sheet has been supplied to the accused persons or not. That's a mandatory requirement, because without which the accused will not able to defend themselves or himself. So it's a mandatory requirement, and that's why when we start this chapter on warrant cases, the first section says compliance with section 230. So magistrate will first see whether 230 is complied with or not. That means the copies of charge sheet etc. has been handed over to the accused or not, without which the accused cannot defend himself effectively. So when in any warrant case instituted on police report, the accused appear or is brought before a magistrate, at the commencement of the trial, the magistrate shall satisfy himself that he has complied with the provision of 230. So that's the one thing which we'll look at, that he will see that whether 230 has been complied with. That's the first step. Next, 262. When accused shall be discharged. Remember the same when we discussed earlier the session trial, where also we have seen the similar provisions. That the first step is there may be discharge application. So within 60 days, the session court has to decide on discharge application. Here also is a similar thing. 60 days timelines are there. So copy has been supplied. The matter has been ready for the trial. Before that, accused might file applications for discharge application of 60 days from the date of supply of the copies document under section 230. Yeah, in earlier also says why this word discharge is there. It could have been said acquittal. Now the difference between acquittal and discharge is If someone is released from the case after framing of the charge, it's amounted to acquittal. When someone released from the case before framing of the charge, it's amounted to discharge. So still charge has not been framed. Case has been either with the ACGM or CGM, or it may be transferred to other judicial magistrate first class. That judge will ensure that the 230 is complied with. Once it is proceed, then the issues of discharge will come. If upon consideration the applications, police report and other documents sent within under section 193 and making such examination, if any, of the accused, either physically or through audio, video, electronic means as the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate finds, after looking at this charge sheet copy or other document, he may produce something in written form or documentary form. So court look into everything. Court does not accept in that sense submission of evidence, witnesses at that stage, because I said already that before charge that will be amount to a mini trial. But yes, if the accuser submitted an application with some basic documents which they have submitted, court may peruse it. Court may also peruse 193, whatever the documents are there, so charge sheet copies. And if the magistrate is satisfied, there is a groundless case, no material, no evidence, then what magistrate can do? Magistrate can discharge the accused, and then he has to, whatever is a judicial order, so every single judicial order need to be reasoned. So the magistrate has to give reasons why the magistrate is passing that order of discharge. So in Srilekha Santi Kumar case, court says while exercising the power under 239, merit of the dispute facts of the case. So like it's not taking entire evidences etc. at this point of time, because I said already that it will be amounted to double trial, mini trial within the trial itself. But yes, whatever the 193 evidences are there, if the court is prima facie satisfied, there is no cases made out, they can discharge. If court is satisfied that no, there is a prima facie evidence, court can proceed to frame the charge. There is another case called State of Karnataka versus M.R. Hiremat. So entering into the questions of evidentiary value of material adduced by the prosecution at the stage of not permissible. It's a prima facie evidences. You don't require to go very detail on those evidences at this point of time. So if the accused did not discharge, what is the next step? Framing of charge. What 263 says? If upon such consideration, examination, if any, and hearing the magistrate is of opinion that there is a ground for presuming that the accused has committed an offense. So, from the material which is being produced, which is submitted in the charge sheet, from those materials, court's prima facie satisfied that there is a ground to believe that accused has committed an offense, triable under the chapter, which such magistrate is competent to try, and which in his opinion could be adequately punished by him. He shall frame in writing a charge against the accused within a period of 60 days. Now, the 60 days timeline was not there earlier in old law. It's there, it means CRPC, it was not there. Now, they have this timeline from the date of first hearing on the charge. So, whatever the date was there for first hearing of the charge, within 60 days timeline will be there. Then what to do? Once they proceed for framing the charge, court can read over and explain to the accused, and he shall be asked whether he plead guilty or not, the charge or claim to be tried. So whether he want to plead guilty or he want to face the trial. So the similar kinds of language we also find when we discuss about the session trial. So in warrant trial also, the either court discharge, if they are not discharging, they will proceed to frame the charge, and then that charge will be read over to the accused under 263. 264 says, what if the accused plead guilty? It says, yes, I did it. Then court can convict. Now here also the word used is may. So it's not that the even accused plead guilty, always court can convict. It is a discretion. So when a recording of the plea shall, so magistrate will record mandatorily, and may means discretionary. in his discretion, convict him thereon. So, magistrate can be convict the persons. Now, if the accused is not plead guilty and want to face the trial, 265 says evidence of prosecution will start the same manner, the manner in which the prosecution evidence is started for the in the session trial. So 265 clause 1 says if the accused refuses to plead or does not plead or claim to be tried or the magistrate does not convict the accused under 264, magistrate shall fix a date for examination of witnesses. So the witness examination date will be fixed. And it also says provided that the magistrate shall supply in advance to the accused the statement of the witnesses recorded during investigation by the police. That's what 230 compliance. 2 says the magistrate may, on the application of prosecution, issue a summons to any of its witnesses, directing him to attend or to produce any document or other things. So if the magistrate on the prosecution evidences, if the prosecution say that, okay, they want to examine these 10 witnesses or 7 witnesses, many a time these witnesses' names are given already in the charge sheet. So the PP knows which are the witnesses to be brought. Accordingly, the name will be given to the court and to them the process will start, so someone will be issued. Clause 3 says, on the date so fixed, the magistrate shall proceed to take all such evidence as may be produced in support of the prosecution. So, magistrate will take all those evidences in support which for the purpose of prosecutions, provided that the magistrate may permit the cross-examination of any witnesses to be deferred until any other witness or witnesses have been examined or recall any witnesses for further cross-examinations. Now, we discussed the same thing was there in session trial also, and I explained earlier. On many occasions, when say for example, and the PW2 will say something on which there might be some clarity will come by PW4. Defense lawyer may say that, okay, they want to cross-examine PW2 after PW4 examination. Court may say, okay, do cross-examination later on. So that's the power has been given there, but the prerogative is with the court. Court can decide. Last proviso says, provided further that the examination of witness under this subsection it can be conducted by audio video electronic means. Remember, in the new law, apart from these sporadic different places references of audio video electronic means, there is a section 531 which permit that in every single processes under the BNSS can be conducted by audio video electronic means. So the audio video electronic means by which it can be conducted. Okay. So now the prosecution witness is over. Now what next? The next is defense witnesses. So accused shall then be called upon to enter upon his defense and produce his evidence. And if the accused put in any written statement, the magistrate shall file it with the record. So now the accused can give his witnesses and their witness examination. If the accused, after he has entered upon his defense, applies to the magistrate to issue any process for compelling attendance of the witnesses for the purpose of examination or cross-examination or the production of any document or other things, the magistrate shall issue such process unless he consider that such application should be refused on the ground that it is made for the purpose of delay or defending end of justice. So there are many times where the defense lawyers do this kinds of a technique just to delay the processes. So if it is court is satisfied that this entire thing is done just to delay the processes, then in those circumstances court may refuse, but otherwise the magistrate will order for bringing those witnesses. So someone will be issued to all those witnesses which are identified by the accused person. provided that when the accused has cross-examined or had opportunity to cross-examine any witnesses before entering on his defense, the attendance of such witnesses shall not be compelled under this section unless the magistrate is satisfied that it is necessary for end of justice. Remember, if the accused has already done cross-examination, then question of examination again does not arise. So that's why these provisions are there. Exceptional cases, it is possible that the court may give permission for it. Provide further that the examination of a witness under this subsection may be done by audio, video, electronic means. These kinds of wordings you will find in almost all trial processes. The magistrate may, before summoning any witness on an application under subsection 2, require that the reasonable expenses incurred by the witness in attending shall be deposited to the court. Now here again is may. Now depending on the situations, court may pass these kinds of order. The power. It is not always they use this power. Now, so this was till this part. It is talking about cases instituted on police report. Now, what will happen? What will be the procedures when cases is not instituted on police report but on complaint? So it uses the word other than police report. It basically implies complaint cases. Now, in complaint cases, we have a little lengthy processes under the law, and it needs some explanation. I'll explain this why lengthy processes. So, in cases instituted otherwise than police report, 267 says evidence for prosecution. Many times this is complainant. So when in any warrant case instituted otherwise than on police report, the accused appears or brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. It says the magistrate may, on the application of the prosecution, issue a summon to any of the witnesses. So whatever the name the prosecution will say or the complainant will say, they will issue the summon. Now, all these evidences of prosecution is examined. But after examining all those witnesses, etc., if there's no prima facie evidences, court thinks that not enough evidence are there, then what to do? 268 says accused shall be discharged. So it says upon taking all the evidence referred to in section 267, the magistrate consider for the reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. Now again, discharge what is there, what that means? Still charge is not framed. Magistrate can discharge the accused. Clause 2 says nothing in this section shall deem to prevent the magistrate from discharging the accused at any previous stage of the case. If for the reasons recorded to be in writing by the magistrate, he considers the charge, consider the ground charge to be groundless. So if the charge are groundless, no justification of proceeding, magistrate has liberty to discharge. So they can discharge the accused. The accused is not discharged. So same way, it can proceed for framing the charge. So if such evidence has been taken at any previous stage of the case, the magistrate is of the opinion there is a ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try and which in his opinion could be adequately punished by him, he shall frame in writing a charge against the accused. Did you see the difference? In case of cases instituted on police report, the charge was framed in the beginning before starting evidence of prosecution. In the cases instituted otherwise than police report, that means on complaint cases, charge is framed after the prosecution witness is over. So charge is framed at the later stage, once the entire examination is over, and that's the differences between these two. Now, remember what happened in practice. As because now the charge is being framed, accused has right to defense. So in practice, what happened is those who are going to the court, you will find in these complaint cases of warrant cases, which the complaint is being filed, what the defense lawyer invariably do is, all the prosecution examination chief is done. He will not do cross examination. He will do later on. He will say, I will do later on. If the accused is discharge. If the accused frame the charge, now those witnesses will again call one by one. So what happened in practice, it delay the processes. So the invariably witness in practice required to come twice. First, at the time of examination, when examination is done by the prosecution. Second, after framing the charge, the defense will call those witnesses one by one for the purpose of cross-examination. Clause 2 says, the charge shall be then read and explained to the accused, and he shall be asked whether he plead guilty or has any defense to make. So that's the general process. Clause 3 says, if the accused plead guilty, the same processes. 4, if the accused refuses to plead guilty, he does not plead or claim to be tried, or if the accused is not convicted on section 3, he shall required to be state the commencement of the next hearing for the case if the magistrate for reasons to be recorded in writing so think fit forthwith uh, whether he wishes to cross-examine any, and if so, see here. So forthwith whether he wishes to cross-examine any, and if so, which of the witnesses for the prosecution whose evidence has been taken. So now the defense will say, no, I will cross-examine all of them. So now those witnesses will come one by one, and again they will be cross-examined. Clause 5 says, if he says he does not wish the witness named by him shall be recalled, and after cross-examination and re-examination, if any, they shall be discharged. The evidence of any remaining witness for the prosecution shall next be taken, and after cross-examination and re-examination, they shall be discharged. Where despite giving opportunity to the prosecutions and after taking all reasonable measures under the Sanhita, if the attendance of the prosecution witness under subsection 5 and 6 cannot be secured for cross-examination, it shall be deemed that such witnesses has not been examined for not being available, and the magistrate may close the prosecution evidence for reasons to be recorded in writing and proceed with the case on the basis of material on record. So if the witness does not appear for cross-examination, then examination in chief has no role. So it shall be deemed that such witness has not been examined. This part is done, then again the defense issues comes. So the accused shall then be called upon to enter upon his defense and produce his evidence, and the provision of section 266 shall apply in the case. So the accused will start giving his witnesses. So in warrant trial, we find there are two processes. One process is when the case is started on police report. Other processes we started other than police report. In normal sense, it is the charge is framed initially, and then all the prosecution witnesses are examined, cross-examined, etc. In cases otherwise than police report, that means in complaint cases, charge does not framed immediately. All the prosecution witnesses are examined, and after their examinations, then court may frame the charge. And once after framing the charge, they can be asked to do for cross-examination. So again, those witnesses will appear. The purpose of cross-examination, they will come for cross-examination. Now this is over. Now the conclusion of trial. So evidence of prosecution is over, evidence of defense is over, examination in chief, cross-examination, re-examination, everything is over. Now the questions of are they get acquittal or conviction? Remember, once charge is framed, the outcome after charge shall be either acquittal or conviction. Before charge frame, the outcome can be discharge, but after charge frame, it can be either convictions or acquittal. 71 says, if in any case under this chapter in which the charge has been framed and court finds that the accused not guilty, he shall record an order of acquittal. Remember, because the charge is already framed, accused is found not guilty, the outcome will be acquittal. Where in any cases under this chapter, the magistrate finds that the accused guilty, but does not proceed in accordance with the provision of 364 or 401, he shall, after hearing the accused on the question of sentence, pass sentence upon him. Here also, the questions of sentence hearing. It is a mandatory process, even in warrant cases, that court must hear the accused on the point of sentence before giving the. In any case under this chapter, a previous conviction is charged under the provision of subsection 7 of 234, and the accused does not admit that he has been previously convicted as alleged, the same way the language was written in the session trial, the same thing is being written here. That court will look into. Now, absence of complaint, 272, general principles. What will happen? What are the consequences? Is when the proceeding have been instituted on complaint, that means complaint case, and on any day fixed for the hearing of the case, the complainant is absent, and the offence may be lawfully compounded or is not a cognizable offence, the magistrate may, after giving 30 days time to the complainant to be present in his discretion, notwithstanding anything herein before contained, at any time before the charge has been framed, discharge the accused. So if the accused are consistently absent, then there can be. First, we have to give opportunity to the victim also to come. 273 says compensation for accusation without reasonable ground. If without any reasonable ground, some cases are being brought, then court may issue order for compensation. So very powerful sections, but rarely used. So if in any case instead upon complaint or upon information given to the police, etc., when those are there, court can pass this kinds of order. Very detailed section. In warrant trial, we have already seen the charge framing 60 days, discharge application 60 days, all those timelines are there under the BNSS in many places. Law has in timeline, the law has incorporated in many places the timeline within which the trial need to be, different processes need to be completed. Not the whole trial, but the specific component of the trial can be completed within a specific time. (272) magistrate shall give 30 days notice to complainant to be present. So we will find these kinds of provisions. Okay, so that's the warrant trial. Now, what we have seen in warrant trial is the warrant trials. Again, there are two components. Warrant trial instituted on police report, warrant trial instituted otherwise than police report. Warrant trial instituted on police report, the charge is framed in the beginning and then the case proceed. Warrant trial instituted on the police on other than police report, then the prosecution witness are examined in the beginning, then only the charge is framed, and then after framing the charge, the accused may ask for cross-examination and those witnesses will reappear. So accordingly, this process become very lengthy and this examination process take much longer time in practice in our system. Now we come to the next kinds of trial. So after warrant trial, we have summon trial. The trial of summon cases by magistrate. Remember, summon case implies where the punishment is up to 2 years. Those are all summon cases. By and large, offenses where punishment is up to 2 years, by and large, they are all non-cog offenses, but that's not the guarantee. There are many offenses also, summon tribal cases, which are cognizable. So in the old law, it was 251 to 259, BNSS 274 to 282. The last part is summary trial. That's we discussed little later. So, how is difference from summon trial from warrant trial? Now, in warrant trial, we have seen there's a requirement of mandatory framing of the charge. When we say framing of the charge, the BNSS says this what should be the content of the charge. So, very detailed provision need to be there to charge. But here, in summon trial, there is no concept of charge, but there is an alternative to charge. What is alternative charge? This 274. Earlier it was 251. We call plea process. So basically, substance of the accusations to be stated. So what the magistrate will do? So when in a summon case the accused appear or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he plead guilty or has any defense to make. But it shall not be necessary to frame formal charge. So there is no requirement of framing formal charge here. Provided the magistrate consider the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. Because the plea has not been started, plea process is not completed. So if one is discharged before that, release from the case, it is amounted to discharge. Now, so basically a substance of accusation is been said. We call it plea process. So in the plea process, if someone plead guilty, then what will happen? So 275 says, if the accused plead guilty, what the magistrate will do? Magistrate shall record that pleading as nearly as possible in the words used by the accused, and may in his discretion convict him thereon. So magistrate can convict the accused. Conviction on plea of guilty in absence of the accused in petty cases. Now, as a general rule, in criminal cases, accused himself need to be present in the court. But for petty offences, we find some different process. So 276 says, where someone has been issued under 229 and the accused desires to plead guilty to the charge without appearing before the magistrate, he shall transmit to magistrate by post or by messenger a letter containing his plea and also the amount of fine specified in the summons. Petty offences traditionally implies where of punishment is only fine. So accordingly here, the court may send summon to them specifying the fine amount, etc. Two, that also possible. So in absentia, accused can plead guilty. So on his behalf, the lawyers can plead guilty and then he can pay a fine. It's normally happen if you go to say in Calcutta Metropolitan Magistrate Court, Bangsal Court. All motor vehicle evidence cases you will find in the CGM. Everyone submit the lawyer submit a guilty pleading. So persons plead guilty and they pay some smaller amount of fine. Now 277 says when procedure when not convicted. So when the accused is not convicted, that means the accused is not plead guilty. Then the trial will start. So if the magistrate does not convict the accused under 275 or 276, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution, and also to hear the accused and take all such evidence as he produces in his defense. The magistrate may, if he think fit on the application of the prosecution or the accused, issue a summons to any witness directing him to attend or to produce any document or other thing. The magistrate may, before summoning any witness on such application, require that the reasonable expenses of the witnesses incurred in attending for the purpose of trial be deposited in the court. That also possible. Now, after those evidences there, court may find him, acquit him, because if there are no evidences. If there are evidences, court can find guilty, convict him. So if the magistrate, upon taking the evidence referred to in 277 and such further evidence, if any, as he may of his own motion cause to be produced, find the accused not guilty, he shall record an order of acquittal. So if the court is not finding guilty, acquit. Where the magistrate does not proceed in accordance with the provision of 364 or 401, he shall, if he finds the accused guilty, pass sentence according to law. So whatever sentences are there, those sections are about the probations, etc. So the court is not giving the benefit of probations to the accused, then court can find him sentences. Whatever the sentences are there, court can impose those sentences. A magistrate may under 275 or 278 convict the accused of any offence triable under this chapter which form the fact admitted or proved he appears to have committed, or whatever may be the nature of the complaint or summon, if the magistrate is satisfied that the accused would not prejudice thereby. So court can convict for other offences. 279 says non-appearance or death of the complainant. So if the complainant die or complaint does not appear, then what will happen? Case will end. So the summon has been issued on complaint, and on the day of appointment of the appearance of the accused or any day subsequent thereto, to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, after giving 30 days time to the complainant to be present, notwithstanding anything herein before contained, acquit the accused unless for the reasons he thinks it proper to adjourn the hearing to the case for some other day. So magistrate, after giving 1 month time, magistrate can acquit the accused person, because remember the plea has already been done. Withdrawal of complaint. Magistrate has a right to withdraw. So if a complaint at any time before the final order is passed in any case under the chapter satisfied the court that there are sufficient ground for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint so withdrawn. So the complaint can be withdrawn. 281 says steps to power to stop proceeding in certain cases. So in any summon case instituted otherwise than full complaint, a magistrate of the first class or with the previous sanction of the CJM, any other judicial magistrate may, for the reasons to be recorded by him, stop the proceeding at any stage without pronouncing any judgment, and where such stoppage of proceeding is made after the evidence of the principal witnesses has been recorded, pronounce a judgment of acquittal, and in any other case release the accused, and such release shall have the effect of discharge. So that's the major thing which they wanted to say here, that okay, uh, if the accused is releasing, plea if it is done, then acquittal, and in other case, discharge. Power of the court to convert summon case into warrant case. Now, remember, warrant cases are higher in nature, more safeguard, charge need to be framed. So in some cases, the court has power, they can convert the summon case into warrant case. Which cases? Where the punishment is more than 6 months and court thinks that is appropriate to convert the warrant summon case into warrant case, they can do so under 222. So summon case 274, magistrate is empowered to discharge the accused. Examination of the witness may be brought by audio, video, electronic means. This is where is a mandatory summary trial process are there. So now we come to the last part of it, trial. We discuss warrant trial, we discuss summon trial. Summon trial process by and large same as the session trial, except that In summon trial, no charge is being framed, it's only plea processes. But plea done in the beginning and then the prosecution witnesses, then that. Now, chapter 22 talk about summary trial. These are last forms of trial. Now, remember, summary trial is conducted only limited number of cases. So, 283 to 288, these sections talking about the summary trial. So, 283 says power to try summarily, notwithstanding anything contained in this adhiniyam, CJM, judgment of first class, they can do some cases, they can try summary, all or any of the following cases. Which offenses? You will find the list. Theft, where property value is not exceeding 20,000. Receiving of those property value is not exceeding 20,000. Assisting in concealment, disposal of stolen property value is not 20,000. Offenses under 331 of BNSS. So some list has been given there. In these cases, the summary trial can be conducted, where the magistrate may, after giving accused a reasonable opportunity of being heard for the reasons to be recorded in writing, they can try summarily. Now, what's the difference in summary trial? Now, as the word suggests, a summary trial, so it does not require to record very detailed examination, summarily everything written. Now, so when you are not taking a detailed process of conducting the trial, what about the accused right? Now, here when the accused being convicted, accused will get lenient punishment. So, there are some leniency has been shown in the act, but it is not as grave or as serious when is other persons we have seen where they can be convicted. So, 284 says summary trial by magistrate of second class. Now, in West Bengal, there is no second class magistrate. Procedure of summary trial. So, what they do in summary trial? In trial under this chapter, the procedure specified in this Sanhita for the trial of summon case shall be followed except after mentioned. So, basically, summary trial is nothing but the summon trial process. 2. No sentence of imprisonment for a term exceeding 3 months shall be passed in a case of any conviction of this chapter. So, if any case where the trial is conducted summarily, the maximum conviction can be given is 3 months, not more than that. Punishment a court can give. So, process in the same way the summary trial being conducted. Recording of summary trial, as the word suggests, the records are maintained summarily. In every case, tried summarily, the magistrate shall enter in such form as the state government may direct the following particulars. So, all these particulars are there. Judgment in case of tried summarily. In every case tried summarily in which the accused does not plead guilty, the magistrate shall record the substance of the evidence and a judgment containing a brief statement of the reasons for finding. So, court can pass accordingly the judgment and the reasons for which court found guilty the accused person. Language of record and the judgment. Every such record and judgment shall be written in the language of the court.